There we go. Awesome. Well, thanks everybody for joining in. I'm going to start doing my little bit of an intro here and just setting up so that when most people are logged in, they can hear Alyssa speak. But thanks for logging in, and as you're kind of getting settled with your lunch, I'm excited that you're here with us. I do want to take a couple of seconds just to say thank you. By the way, I'm sharing my screen, right, Elizabeth?
Yeah.
Take a couple seconds to say thanks to our partners. We've had a lot of great partners this year, and really grateful to all of them for the support that they've given us over the course of the year in all kinds of ways. So thanks to all of them. Thanks to all of you for joining as well. A couple of notes on my end. We have the 2025 annual Trends event coming up tomorrow night. So this is going to be great. We've got, at last count, I think there's about 230 people confirmed. We've got tickets for about 20 more seats. So if anybody's interested, please feel free to sign up. And that's going to be a great night. It starts around 4:30 for networking. Drinks start around the presentation start around 5:30, and we'll be wrapped up by 8. So that'll be a really great opportunity for getting together and chatting with people before the Christmas. Our vision for the Calgary Marketing Association is to make Calgary known as a world-class marketing community. I'm sure if any of you have logged into previous webinars or been to any other events, you've probably heard me say this a few times now. But I really think this is a good vision for the Calgary Marketing Association to take on. One thing that I realized was missing, and I spent some time with Rob at ZGM and Carol Schmeigel working on, was a more brand positioning document. And so we now have this promise that I want to make to you. And the promise is that actually we can make together, and the CMA can support this, is by joining the CMA, what we're promising is that you'll become a world-class marketer. But it takes two. So people need to invest in themselves, and we also need to invest in you. And so from our perspective, it's the commitment at the center of everything that we offer. So evidence-based learning, community, forums, events, practical wisdom, all designed to help Calgary marketers level up and get recognized for it. So that's our promise, and we're going to kind of stick by that. Including, as a way to make good on our promise, today we've got Alyssa Riccioppo. Did I get it right?
You got it.
Yeah. Okay, good. Alyssa is a board member of the CMA, and really grateful to have her join us on that, but also happens to be wicked smart intellectual property lawyer who does things in entertainment law, trade media, or trades, branding, trademarks and branding, and is really, kind of digging into a lot of the emerging technologies that are coming out with AI. We were chatting a while back around some of the rules and restrictions and legalities around things like digital influencers and AI creators and all that kind of stuff, and thought this would be a really cool topic for a webinar. So luckily for us, she's here to join and kind of give her thoughts on the landscape and give us some ideas around how to manage and navigate this space. So Alyssa, thanks so much for joining us, and I will turn it over to you. For anyone that's joining in and listening, we're going to take or you just put in comments into the chat and questions as they come up. I'll keep an eye on it, and at the end of the presentation, let's just save time for us to address a lot of these questions. So just keep putting them into the chat whenever you feel like something is relevant, and then we'll get to it at the end. So Alyssa, over to you.
Okay, perfect. Let me get my slideshow up here. Okay. How's that look for everybody? Coming through?
Yep, that's good.
Okay. Okay, yeah, I can't see the chat while we're talking, so we'll take a look at it after. Okay, so thank you, Mark, for the introduction, and I am really excited to be here. These are all topics that are very interesting to me because they're new areas, they're old areas of the law that are being applied in new ways, which requires creativity and exciting things. So today we're going to talk about intellectual property law, some of the law around artificial intelligence, and then influencer marketing, and then how all three of those concepts work together. I'm an associate at Miller Thomson. We're a national firm. We practice in all areas of the law, and I'm part of the technology, intellectual property, and privacy group. So within that, I specialize in entertainment and marketing and advertising law, and I'm a trademark agent as well. So we're going to cover some stuff about trademarks in here. So, like I said, first thing we're going to do is take a look at what is the regulatory landscape for each of those three areas. So we have AI, IP, and then influencer marketing. And then we're going to look at actual practical applications of AI in the marketing and advertising space, specifically with influencers, and how there might be some legal pitfalls or risks and decisions that can be made to deal with those. And then the last one is some practical tips for you guys to think about what to include in internal policies, external policies related to AI specifically, and then your contracts with influencers or AI service providers and tool providers. Okay, so starting with regulatory landscape. We'll start with the regulation of AI because it's a pretty quick and simple slide. So I like to kind of show the EU and the US on the same slide as Canada to do a bit of this like Goldilocks type of approach. The EU is the first jurisdiction in the world to come up with a comprehensive regulatory scheme for AI. And the Artificial Intelligence Act in the EU was passed in May of 2024. So it's been around for a little bit now. If people have any kind of critique of the AI Act, it's usually something about how it's considered a bit of an overly strict approach, and that by being too strict, maybe they're stifling innovation a little bit. But what they're focused on is avoiding risk. And so they have this kind of risk-tiered approach to classifying different types of AI tools and the types of rules that apply to them. And they have really strict obligations about doing risk assessments and maintaining transparency and accuracy and things like that. So if that's the one side of like potentially it's considered too hard on AI, then we have the US that's sort of on the complete other end of the spectrum. Right now, there's no comprehensive AI regulation at the federal level in the US. There are some states that have been passing around ideas and coming up with how they want to regulate things. But right now, at the federal level, it's really just sort of loosey-goosey, non-binding type things like guiding principles or executive orders and white papers that are making suggestions, but not really creating strict enforcement or rules around use of AI. And the reason for that the US government has said is that they don't want to stifle innovation. They don't want to make things too difficult to come up with new and exciting AI applications. So Canada, question mark, question mark, question mark. I used to have their are we just right? Because basically Canada, in our proposed Artificial Intelligence Data Act, or ADA, you might hear it called sometimes, we had this plan where it was going to be sort of perfectly in the middle. It was going to have risk assessment type language, but it was going to be a little bit less strict than the EU. But that act died earlier this year. So that's why I have it crossed out. RIP to ADA. But so as a result, we're kind of more like the US right now. We don't really have any comprehensive guidance. What we do have is a voluntary code for the responsible development and management of generative AI systems. This came out in 2023, and you can see on the slide there what the principles for this code of conduct are. I like to highlight this in my presentations on this topic because I think if anyone's thinking about developing an internal AI policy, these types of principles from the voluntary code of conduct are a good place to start, because these are the types of things that when I'm drafting policies or reviewing them for clients, we usually incorporate things like accountability and transparency and human oversight, because those are designed to deal with some of the potential risks associated with AI. So that's the regulatory landscape for AI currently, which is to say not a lot going on in Canada. Let's take a look at intellectual property. IP is a super, it's a niche area of the law, but it also covers a lot of different things. So I'm trying to keep this like super high level. We're just going to focus mostly on copyright and trademarks, because that's what's most relevant to marketing and advertising, and specifically using influencers. But to just kind of take a step back and give a general concept of like, what are we even referring to when we're talking about IP? That's what we have on this slide. So intellectual property is the intangible assets. And so things like processes or formulations, and it's taking those and putting those ideas into an actual tangible form. So that's why I always keep this quote on the slide here, that ideas aren't enough, something has to be done. There's no protection in intellectual property for a concept or an idea or an approach. There's protection for when that thing actually gets put into a tangible form. So if you have an idea for a book in your head, you can't sue someone for copyright infringement if they come up with the same book. But if you publish that book and it's now physical and someone copies a significant portion of that book, now we have a copyright infringement claim. So these are the types of things that could attract intellectual property protection. And what I mean by that is those things on the last slide, like methods and recipes and formulas and software, they can all fit into one of these 5 categories of intellectual property protection. So I'm sure everybody's heard of patents, trademarks, copyrights. Some people probably heard of industrial designs as well. That's Canada-specific concepts. In the US, they call them design patents. I'm not going to go through, this is like a lot of content on one slide. So feel free to take a picture or look back on the recording when you receive this, or if anyone wants to request a copy of the presentation, we can send that out as well. But this is sort of an at-a-glance table that shows you what are the different types of formal protections that you can like file for to protect your intellectual property. What does it actually apply to? And then how long does that last for? So on the right-hand side, we say monopoly granted. I like to tell this little story about the origins. I heard it on a podcast, but I believe it to be true. The origins of patent law and intellectual property. There's a story that it goes back to ancient Greece, and there was a law that was passed related to feasts and chefs that were making really delicious meals. And they basically wrote into the law that if a chef makes a really great meal that everybody loves, then only that chef can make that meal for an entire year. And then after that year, other people are allowed to make it. And so that's often cited as the origins of the concept of patent protection, which is and all IP protection. You have a monopoly over this certain intangible asset in its fixed form. Other people can't use it. Whether it's an invention, which would be a patent, or if it's a word or a slogan or a symbol, which would be a trademark, or a song or a dance or software code. Those are all examples of copyright. The last one on here is trade secret, which is sort of a different one because you don't really file an application or registration for trade secrets in Canada. It's sort of the alternative to doing a filing. So when you do filing for formal IP protection, you get this monopoly. That's great, but it's time limited. And for something like a patent, you have to disclose how the thing actually works. So for example, companies like Coca-Cola, KFC, rather than trying to seek formal protection through one of these other methods for their secret recipes, they said, well, we don't want to have to disclose it, even if it means that we'll get a monopoly. So instead, we'll make sure to put protections in place to make sure that no one ever knows what the secret recipe is, and then we can have lifetime and multiple lifetimes worth of protection rather than limiting it to a time-limited period. Again, that's already too much on this slide, but if people have specific questions about other forms of IP, let me know. But let's dive in a little bit more into copyright and trademarks. So the main things about a copyrightable work to keep in mind are that it needs to be this fixed expression of an original idea. So it's not the idea itself, it's the expression of it. Originality is something that was decided very specifically in Canada in this one case that I cited up there called the CCH case. Boringly, for everyone other than lawyers, it was about whether there's copyright in like the head note summary that goes at the top of a court judgment and whether that's infringing on the actual judgment itself. And they went into a big discussion about that. But the result was that in Canada, for something to be considered copyrightable, it needs to be original. And to be considered original, it needs to show the exercise of skill and judgment. So that's considered to be a higher burden to meet than something like sweat of the brow, which is what the test used to be, which is sort of, if you try hard enough and you show you put a lot of work into this, we'll say that you can have copyright. But it's not all the way so far on the other end to like, this has to be creative and completely novel and something we've never seen before. It's okay if it's something we've seen before, as long as you're using skill and judgment in the way that you're putting it together, then you likely have copyright protection in that thing. You don't need to register copyright in order for copyright to exist. It exists the moment you create something. So I often will say that, I created this presentation. If anyone's taking notes on what I'm talking about, you're the author of those notes. And so you own the copyright in your notes, but I'm the author of the presentation. So I would own copyright in the presentation. That's the baseline rule for authorship and ownership. Usually the first person who creates something is considered the owner. However, that would actually be incorrect in this case because I created this presentation in the course of my employment at work, and there's a specific exception in the Copyright Act that if an author creates something in the course of employment, the owner is actually their employer. So the takeaway from that concept is that I try to highlight for clients that if you're working as an employee for a company, or if you're an employer working with an employee, that's the baseline assumption in the law, is that the employer will own the copyright in the work. But then you run into questions about like what's considered the course of employment, things like that. So rather than relying on this presumption that's in the Copyright Act, it's always best to include assignment language saying that the employer or whoever is appropriate for the situation owns the copyright. And the opposite's true for independent contractors. So if you're working with an independent contractor, it's assumed that they own the copyright in their work unless they've assigned that over to you. And that's true even if you pay them for it. The Copyright Act says an assignment is only valid if it's in writing and it's signed by the parties. So just because you paid someone to do some work, if you don't have a contract in place with an assignment, then you can run into issues that you don't actually even own that work that they did for you. Which is relevant for the next thing on the slide, which is moral rights. And that's the picture that we have here. So this is a famous case in Canadian legal history called the Eaton Geese case. And it's where a sculptor who was really well known for making naturalistic sculptures of animals created these geese for Eaton Centre in Toronto. And then the center said, well, it'd be really cute it would be really cute if at the holidays we put little red scarves around all the geese, and then everyone would really love that. Except the artist did not really love that, and he sued them for infringing on his moral rights. So what are moral rights? Moral rights are the right to be credited as the author of the work, the right to be anonymous if that's what you want, and it's the right to the integrity of the work. So in this case, the artist's issue was that they had negatively impacted the integrity of his work because he was specifically known for making naturalistic renditions of animals and throwing on these sort of cartoonish, cute scarves, undermined the whole integrity of the work. And he ended up winning his case, and I think he got like, I don't have the number written down, but it's a surprisingly large number of what he got in damages, like tens of thousands or something like that. So the takeaway from the eaten geese case is that whenever you're hiring someone to do work for you, you not only need an assignment of the copyright, but you also need them to waive their moral rights, because if you don't get a waiver of those rights, it doesn't transfer automatically with the assignment. It's a separate set of rights that need to be waived. And if you don't get it, then arguably if you make changes to something, even if you own the copyright, the original author could still have a claim against you for infringing on their moral rights. So that's the language that you often see in contracts about waiver of moral rights. I just want to jump back to the registration bullet point here, because I said you don't need to register copyright to have it. It exists automatically. But there are some benefits to registration, which basically just helps you in a litigation scenario because it creates a presumption that you actually own the copyright and that it's actually valid. And that way, the onus is on the other person who infringed to prove that that's not the case. Whereas if you don't have a registration, the onus is on you to first prove that you even have copyright in the thing. Okay. So, quick overview of trademarks as well. I'm sure everyone here is very familiar with the importance of branding and trademarks. This is always one of my favorite slides to talk about because I like talking about all of the non-traditional trademarks, like sound marks and colors and 3D shape marks, which would be like the Birkenstock shoe. They've been trying to get that. At the bottom, we have Wrangler Jeans has a registration for having a label in the top left pocket of jeans. So they're saying, according to trademark law, that if any other jean company were to do that, then Wrangler would be able to sue them for trademark infringement. Trademarks were once described to me as basically an arrow that points a consumer to the source of goods or products. And so that's what I always keep in mind when looking at trademarks and how to protect them. We could talk at length about the importance of enforcing trademark rights to avoid genericization and things like that, but that's kind of getting beyond the scope of this. But we'll talk more about trademarks and the importance of having brand guidelines with influencers in the next couple slides here. Trademarks also don't need to be registered. You can have common law trademarks. But the benefit of registration is that then you get Canada-wide protection rather than having to prove a certain geographical area where clients or where consumers would know your mark. Okay, last piece of the regulatory landscape. So we've set the scene. This is where the law is at with AI. This is where the law is at with IP. Where's the law at with influencer marketing? There's kind of three areas that I like to talk about specifically for influencer marketing. So one is the general prohibition on misleading advertising. The second is the importance of disclosing material connections. And then the third is testimonials. So first one, the same rules that apply to all marketing apply to influencer marketing. So you can't engage in false or misleading advertising. That's prohibited under the Competition Act. There's similar standards that also prohibit that under provincial consumer protection laws and under the ad standards, Canadian Code of Advertising Standards. So when determining if a specific claim is false or misleading, the courts look at the general impression of how an ordinary consumer would understand that claim and how it would impact whether they would want to buy the product or not. And they look at the meaning of the advertisement as a whole, not just the literal meaning, but also the overall impression, and taking into consideration things like disclaimers. But if that disclaimer is really small and 3 clicks away, is it really an active disclaimer that's effective? To avoid being misleading, claims have to be substantiated, whether it's an express or implied claim, and that substantiation has to be done before the claim is made, not after the advertisement has already been released. And so that's like a quick overview of general no false or misleading advertising. There's also some things that are really specific to the influencer context, whether that's like the method of using an influencer or if it's the type of media that they use. So one of those things is disclosure of material connections. It's considered misleading if an influencer or any person providing an endorsement or testimonial about a product does not disclose all material connections between the individual who's providing the testimonial and the company that they're advertising on behalf of. So a connection can be considered material if it has the potential to affect how a consumer understands the independence of that person who's making the claim. Like, how closely connected is this influencer to the brand? Are they just saying they like something because they do, or are they saying they like something because they do and they're getting paid to say that? That impacts how you think about things as a consumer and whether you want to actually buy that product, right? So examples are not just getting paid, but also free products, discounts on products, trips, exclusive event invites, or getting extra entries into a contest or sweepstakes. Having a personal or employment relationship between the person giving the testimonial and the company would also be considered a material connection. So the important thing here is that those material connections need to be disclosed, and they need to be disclosed clearly, conspicuously, and in a way that can be broadly understood. The ad standards just came out like a couple months ago with a new influencer marketing guide. So I would highly recommend reviewing that for really specific examples of what hashtags to use and where to place them and what to do in video versus if it's just audio or just a visual post without any kind of video or audio component. They have great examples in there. Examples of what's generally considered acceptable is like hashtag ad or hashtag sponsored. And when doing things in video, it needs to be both seen and heard, because you don't know how the consumer might be taking in that information. Simply tagging a brand is never going to be considered sufficient disclosure. You need to have something that indicates it's an ad or a promotion or something like that. The other last thing I just want to highlight on that is that I know that the platforms will have features that assist with doing proper disclosure of advertising relationships, like allowing the influencer or whoever to put like hashtag sponsored on their video and overlaying that over the video. But it can't just be automatically assumed that these platforms are complying with what the rules are in Canada. So it's really important to always actually specifically look at what those features are and if they're compliant, rather than just telling an influencer to just do whatever the platform offers, because it might not be enough. Last thing, testimonials. The Competition Bureau takes the position that consumers are expecting consumer reviews to be expressing real experiences of genuine customers. So if it's revealed that a consumer never actually used a product that they're reviewing, then that's obviously going to negatively impact or significantly impact a consumer's decision as to whether they're going to trust that review or not. So it's incredibly important to avoid enforcement by the Competition Bureau to not engage in activities like astroturfing, where you're creating testimonial type of situation and making it seem like it's an authentic experience or opinion when it's actually like a fake consumer review of somebody who's never actually even used the product, whether that's published by the advertising company itself or somebody else who they're paying but just has never actually used it. And the reason all these things are important is because there are some significant penalties under the Competition Act for failure to comply and for engaging in misleading advertising. And the Bureau has taken the position that both influencers and the brands that they're making content on behalf of can be held responsible for an influencer's post. So it's super important to make sure that when you're engaging influencers, you have proper protections in place in your contracts to make sure that if something goes wrong, even though you might be held responsible as the company, you can then turn around and get compensated by the influencer if it was something that was their fault. And yeah, fines under the Competition Act, there's two tracks. There's the criminal prosecution and there's also the civil track for dealing with complaints and violations. And the fines on the civil side can be up to 10 million on the first offense or 15 million on the second, or it could be 3 times the value of the deceptive content or conduct, or 3% of your annual worldwide gross revenue. So these are not small penalties that we're talking about. And on top of all that, there's always reputational concerns. So it's important to properly vet influencers before engaging with them. Okay, so how does this all work with, like, we've set the scene, we understand what the laws are. And so what does that have to do with actually using AI, and how does using AI change how those laws are enforced, or what the risks are to companies and influencers that are using AI? So first thing is, I mean, I could talk about copyright issues related to AI tools for a long time. There's, how does the copyright work with the input that's going in? Who owns that? Who owns the copyright in the tool itself? And then who owns the copyright in the output? We're just going to focus on output today. So if you're putting inputs into an AI tool, you're giving it prompts, and it creates something that is generated for you, like an image. Who owns that, and what are the implications? So on this slide, we have a photo that was taken by a human author, original photo. And then we have the middle image, which is Starry Night. And he inputted both of these into an AI tool that he created and said, can you please spit out my photo in the style of Starry Night? Nowadays, this is like not really that exciting. But this is all the way back in like 2017 or something. So it was kind of before generative AI became something that you could easily access and use in your own household. The resulting picture on the right is called Surreast, and the human decided to file copyright registration in Canada for the resulting image, and he listed himself and the AI tool as co-authors. So when I do this presentation in person, I ask people to put their hand up if they think that this actually would have gotten through as something registrable or not. And usually most people are like, that's definitely not registrable. Yes, okay, I'm seeing little emojis and things coming up. So the result was that he actually was able to get registration with the Canadian Copyright Intellectual Property Office, which is shocking to some people. But then there's step 2 to the story, which is that yes, he did get registration, but that's because the Intellectual Property Office does not review registration information that people input when they apply for a registration. So he just got the stamp of approval and moved on and said, this is a co-authored piece with AI and I can prove that you can register that. So now, ever since everything has happened with ChatGPT and this is becoming a much more common issue, this is actually like currently under investigation as to whether this registration should be expunged. and the validity completely disregarded. And I think that is what the result will be. It probably will be expunged, but it's yet to be determined for now. And part of the reason for that is that in Canada and in other countries, like I mentioned, to have copyright in something, it needs to be a fixed expression and it needs to be something original. But the other piece is that it needs to have an author. And the reason that we know that is because there's a bunch of things in the Copyright Act that suggest that you need to have an author and that the author needs to be human. So for example, like the term of copyright protection is the life of the author plus 70 years. So if the author is a machine, like how does that work? Do we just have copyright protection forever? That kind of defeats the whole purpose of having that time-limited monopoly that we were talking about at the beginning. And it also talks about authors having addresses and things like that. So the government's currently doing consultations to see if the Copyright Act needs to be amended to deal with AI, or if we can work with the current regulatory landscape that we have and just fit interpretations around AI into that. But basically the types of questions that this leaves us wondering about is if you're using AI in your work to create some kind of ad copy, or if an influencer uses AI to create something for you, who owns that? And right now, the answer is murky. If it's solely generated by AI, I think we know for sure that there is no copyright because there's no human author. But if you can argue that it's jointly created, or that it was a human who did all the inputs, came up with all the skill and judgment, did everything themselves, and just used the AI as a tool, then is that really any different than how photographers currently use, or in the past have used Photoshop, or a painter uses a paintbrush, right? So it's always going to be, again, this is speculation because we don't have guidance on this in Canada, but looking at the US guidance and thinking about it from a historical perspective on copyright, I think the question is going to be, to what extent are you using the AI as a tool to implement your own skill and judgment, versus to what extent are you using the AI as a replacement for skill and judgment? How are we actually going to prove that in practice? Like, are people going to need to print out their prompts and try to prove that? I don't know, because like I said, there's no guidance on it right now. But in practice, the implications of that, in my opinion, are we need to look at a few things. So one is also check out the terms of use for that AI tool that you're using. I know that nobody reads them, but I read them because I write them. So I know what's in them. And I know that they say a lot of things about IP ownership. So first step, whenever you're using an AI tool, always check out what it says about owning input and owning output. Last time I checked, ChatGPT said that you, as the person using it, own all the input and output, but it was like automatically, like the choice was already made that you were granting permission to them to be able to use your input however they want for further training and things like that, which you can toggle that setting off, but it's like assumed that you're going to let them use your input, which can have implications for data privacy and things like that as well. But anyway, so always check the terms, who owns it, what are the limitations on what you can actually do with this. I had a client that I was helping with a trademark application, and I ran the searches that we always do before filing to make sure that the mark was generally available. And there were no registrations or anything in Canada, but there was a search that came up showing that the exact same design was like on Facebook by a different company in a totally different country. And so I just pointed out to the client and was like, hey, you're going to be fine to get a registration in Canada because they don't have a registration and it's a different country, but just FYI, like you might have some questions about whoever designed this logo for you because it seems to be a direct copy of this other one. And then they're like, oh, don't worry about it. We just used Canva. We used Canva to design this, and so it's all good. And then I looked at the terms of use for Canva, and it very expressly said you cannot use Canva to design trademarks. So the client had to go back to the drawing board on that one. So always checking terms of use for restrictions on use and also IP ownership is key. And then the other thing is, if you are using AI, to generate content, whether that's trademarks or other designs, recognize the risk that you may not own copyright in that content. And so if somebody copies it, that's going to limit your claims you have against them. You might not be able to sue them for copyright infringement because there may never have been copyright in that thing in the first place. So that's the main risk. Next slide shows another risk, which is depreciation of goodwill. So this is an example of this is a case, this is a current ongoing litigation between Getty Images and Stability AI, which is this company that was creating generated content, which is shown on the left here. Some of it's a little bit spooky looking, and then there's like real Getty Images on the right. But because they so obviously used Getty Images to do all the training for the tool, the thing that it spit out always was including a Getty Images logo. So obviously Getty Images sued them not just for copyright infringement from training on their content, but also for depreciation of goodwill and the trademark, because now Getty Images is being associated with these weird, poor quality photos that they don't want to be associated with. So, I mean, this is obvious, like we need to have human oversight over the use of AI tools because you don't want to run into a scenario where your brand is being negatively affected because an influencer or whoever just decided to use an AI tool to create something, or that you're accidentally using someone else's brand that you shouldn't have been. Just like last month or earlier this month, the copyright side of this was decided, and the courts, this is in the UK, by the way, but the courts said that it was okay for them to train on the Getty Images materials to train the AI tool. So interesting development. The depreciation of goodwill stuff is still being decided, but I feel like it's pretty obvious that Getty Images is probably going to win that one. Okay, so being mindful of time, we're just on the last two slides here. So when we're talking about influencers using AI, I mean, I've been hitting some of these points already, but that's more about the bottom half of the slide. So when we have a human influencer who's using AI to create materials, what are the risks? What do we need to be aware of? Brand guidelines. We want to make sure that they're actually complying with that so that we avoid the Getty Images situation. Recognize that having them use platform tools that supposedly give proper disclosures might not be sufficient. So it's important to actually lay out your requirements for them in the contract and maybe directly reference, like you need to comply with the ad standards, influencer marketing guidelines that just came out. If you're using AI to generate an effect in some content, or if an influencer is, should that be disclosed? And I think there's some discussion about this in the guidance, but if it could be misleading for people to not know that AI was used to create this effect, then it should be disclosed, right? And just consider if you want to be letting the influencers use AI at all, maybe it's not worth the headache because of all of these things that we've been discussing about today for now, right? But let's take a look at the top half of the slide. So probably some people are familiar with Lil Miquela. She's the biggest synthetic influencer in the world right now. There's also people like Tilly Norwood. Well, not people. There's also AI generated things like Tilly Norwood that are, she's supposed to be like the first AI actor. I heard that the agency that she's signed to is just like the company that created her though, so that might impact her credibility. But anyway, so these are existing. We have synthetic influencers. So what do we need to think about here? Biggest thing is testimonials. You cannot have a synthetic virtual influencer saying that your product tastes so great because they're not able to taste, right? So that's going to be a huge area of risk and potential enforcement if people find out that this is a virtual influencer that you're using and that you are having them make testimonials that they can't make, because there's no way that they could genuinely know that. Same thing, we need to ask, could it be misleading to people if they don't know that this is actually not a real person? I think the guidelines say right now that it's recommended to say if this content is AI generated. It's not required. Is that going to change? I don't know, but that's the current guidance. And then I also just want to highlight, other than synthetic influencers that are totally brand new, we also have AI replicas of existing people like actors. And this is becoming, I think, much more popular, where it's like you could have someone show up for one day of a commercial shoot, get a bunch of footage, and then have them sign something that says, okay, are you fine with us taking everything we've shot, creating an AI replica of you, and then putting them in 5 other commercials doing different things that we didn't even shoot today, but that we can now do because we have those capabilities. And that opens up a whole new can of worms around personality rights and union negotiations, like if they're a member of ACTRA or things like that. So just want to highlight that as another potential issue related to AI and influencers. But we'll go to the last slide. Practical tips. So I don't mean to scare everybody by talking about the legal pitfalls here. Obviously, AI is going to be a big part of all industries, and specifically this industry going forward. So how do we go forward in a smart way that protects legal rights? First thing for AI is like do an inventory. What are you currently using? What are the tools you're currently using? Do they have limitations? Like, does it say that you can't be using it for commercial use or to create trademarks? And are you in breach of that? Is it compliant with privacy laws? Is it introducing new issues in your business that you didn't have before that you now need to be aware of? You're also responsible for what your AI tools do on your behalf. So if you have a chat bot, like this happened, there's a Canadian case about this. If you have a chat bot that gives a consumer false information, then you can be held responsible for that. You can't just say like, oh, our AI had a hallucination, and so we're not responsible. Just like you'll be held responsible for activities by influencers. Consider having an internal AI use policy that explains to employees what they can and can't do, that they can only use specifically vetted tools rather than anything that they want. Consider maybe that you only want to use products that have reps and warranties in your contract with your service provider that say that it was trained on licensed materials and that they didn't scrape the internet for personal information to train their tool on that's then later going to be the subject of litigation, like what happened with Getty Images and Stability AI. Think about who owns the tool. Was it created just for you? Is it like an internal tool that's being trained on only your data, and so you want to own all that? Or is it owned by the service provider and they can take the benefits that they've gained from training on your info and use it for their other customers? Data protection is something we've not talked about a lot today, but is a big piece of AI tools. On the IP side, understand what your rights are in the content. Do you own it? Is it ownable? Do you have a waiver of moral rights from the authors that contributed? Do you have an assignment or a license to use that material? Do you have registrations in place for your trademarks and other materials, or are you relying on common law rights and unregistered marks instead? What are your brand guidelines, and do they maybe need to be updated now in connection with using them with influencers or with AI being a key part of business now? And then last thing is thinking about your policies and contracts for influencers. So best practice might be to actually have some kind of training for your influencers to make sure, because you're held responsible for what they do. So why not be proactive and make sure they actually understand what they're doing? Maybe have strong guidelines about both internally the types of influencers you want to work with, and externally giving those brand guidelines to them and perhaps prohibiting the use of AI. Who owns the materials that are created by the influencer? Do they own it? and they're just letting you use it, or do you own it? I've seen it both ways in influencer agreements. Give them the guidelines, tell them they need to comply with the Competition Bureau ad standards. Like there's a lot of materials out there that give guidance on this. And so we incorporate that directly into the contracts and say you need to comply with these things or else it's a breach of contract. Think about reputation clauses. This is just the sort of a last one that I'll leave as some food for thought. I recently heard about this at a conference. Like, we'll often put something in that says, you're not allowed to say anything negative about our brand or our products. But then isn't one of the requirements for testimonials that they have to be telling the truth? So now there's sort of this discussion about like maybe that type of clause actually isn't enforceable and you're actually forcing them or trying to encourage them to breach the Competition Act. So instead, maybe don't say things like that, just say that the testimonial has to be truthful. Don't use AI influencers to make testimonials if that's the case, if they can't possibly truthfully have an opinion about this particular issue. But also think about having the rights to terminate in the event that the influencer does something that doesn't fit with your brand reputation and things like that. So a lot of content. Like I said, you'll have access to the recording, and I'm happy to give the presentation to anyone who requests it as well. But I'll open it up to questions now.
Yeah, this is awesome. So so many things to I one thing I realized for sure is I'm not a lawyer. I have no idea how I would even know any of that kind of stuff. And it's funny because they just kind of do a lot of things without thinking what the implications are
Yes.
and not even realizing I'm necessarily putting myself at risk or the company or whatever at risk. So yeah, lots of great things to think about. There's a couple questions for sure that, and if anybody has questions, feel free to type them in now. There's one from Trevor. Hey, Trevor. So with influencer marketing, where there is a live event and the influencer genuinely forgot to formally recognize a material connection during the broadcast, it wasn't an intention of the brand to mislead. Is there a remedy?
I so like that would still be considered misleading. But are you saying like what can we do after the fact to try to
Yeah.
deal with that? Uh, I mean, I guess you could try to um release some sort of statement or something to clarify that, but it might sort of just be like the deed is done. I think you'd have to do an assessment from like a business risk and legal risk perspective about whether you want to address that further or not. But that would be problematic in the event that it was detected and enforced against. Both the influencer and the company would be held responsible.
Hmm.
Yes, after the fact. Okay, yeah. Yeah, how could you remedy it? Short of like sending out a blast to everyone who attended the event to explain it, I'm not sure what else would be able to accomplish the material disclosure that you need to make. Yeah, that's
Gotcha.
one.
Okay,
What?
thanks. I had one that I had written up. There's like a whole bunch. My brain went in a whole bunch of different directions related to the value of a brand, and I think
Mm-hmm.
oftentimes we're talking about defending brand from an advertising perspective and looking at branding and how important it is. But then you had a trademarks conversation on like the pocket design of uh,
Yes.
Wrangler and things like your Birkenstock shoe style, and there's all kinds of things like that, and that have like because there's legal cases and payouts, there are definitive financial values for brand elements. So
Yes.
it's kind of interesting. On one hand, we're saying like brand isn't worth anything. On the other hand, there's probably a whole boatload of cases, legal cases that would prove exactly the opposite.
Yeah, like from a legal perspective, I do very much think that brand is worth a lot. Like I've seen sort of just like anecdotally, I've seen that having a registered trademark can add like tens of thousands of dollars to the value of a company, as opposed to if they don't have any formal IP registration. And the Canadian Intellectual Property Office has released reports where they talk about like small and medium-sized businesses and their use and understanding of intellectual property. And I just know this off the top of my head because I was looking at it the other day, but it's something like small businesses that have formal IP registrations are like they get 3 times more funding from investors and grant
Oh,
programs
wow.
and things like that than other types of businesses. So it's it's a valuable thing for sure. But yeah, things like the non-traditional trademarks like sounds and scents and things, you have to be able to prove that you've actually acquired distinctiveness in that thing and that consumers actually do recognize you as being the only thing that is that color or that scent or whatever it is. Because otherwise it would just get too messy. Like claiming exclusivity over a color is a pretty large claim.
Yeah, that's a tricky one.
Yeah.
But like the McDonald's jingle,
Yep.
like that'd be something you could easily,
Definitely. Yeah. I
especially
wonder
with
if they
brand
have.
trackers, probably like
Yeah.
that, so that your brand is linked to specific assets.
Mm-hmm.
Interesting.
Yeah.
Thanks. Okay, Kaylin's got a question. If a company were to edit an image that they own from a photographer,
Mm-hmm.
for example, removing models from the image, would these
Mm.
be an example of impacting the moral rights of the photographer?
Yeah, it could be. If you have like if you own it because you got an assignment of copyright, then that's great. But then yeah, you need to make sure you have that second piece where the photographer waives their moral rights so that you're allowed to edit the product or like the work. Um, it kind of depends on whatever your agreement is. Like maybe we could imply that if it says in it that you have a right to edit the work, then you don't need a waiver. And if this photographer isn't specifically known for a specific thing, then it might be hard for them to argue that making changes to something that there was an understanding between you that you'd be allowed to make those changes. It might be hard for them to make that case, but yeah, like that's why just anytime you're getting an IP assignment or license to some content that you want to use, we just always want to include a waiver of moral rights so you don't get into that situation.
Um, that's awesome. I'm gonna steal your screen for a second, Melissa.
Okay.
So for everyone who's still on, just a couple of quick notes from me, and thanks for all the great stuff you presented there, Alyssa. I think I took a whole slew of notes, so I'm sure
Okay, good. You
there's probably
uncover it.
everyone that's going to have other questions too and that kind of thing.
Yeah,
So feel free to send those in too after the webinar is over if you guys are interested. A couple of things coming from us just to talk about a few things that I think are important before we get into the new year. There's one thing that I wanted to share. Am I sharing my screen?
yeah.
Yeah. Okay. So we have a new course coming in the winter of 2026. Or sorry, not I shouldn't say winter. It's just say Q1. So it's the first time we've ever done this. We've got an effectiveness system course that was created in Sweden, where we got some rights from them to be able to share that and offer that to our members. So this is a really cool standard that they use in Sweden, which is the effectiveness system, which has 36 KPIs that are categorized. It looks like a periodic table, but they're built off of evidence-based principles. So it's a really cool way to get a CFO-friendly way to measure real impact. So that's something we're doing. I also am at the moment, I'm booking meetings with anyone who wants to talk about partnerships and strategy and sponsorships for the new year. There's lots of opportunities here to do that. And also influencing events like this that we're doing with the list. Maybe we'll get a list back. So if anybody is interested in doing that, then feel free to scan the QR code. And really, that's it. I wanted to say thanks again to Alyssa for all your thought and work on putting this together. It's so awesome to hear about this. It's such an interesting area. Like I said, I just often do stuff without really thinking about the consequences. So this is great.
For sure. Yeah. Thank you for having me.
My pleasure. And thanks to all of you for logging in. And that's it. And as I said, we've got this event tomorrow. So if anybody's coming tomorrow to the Trends event, we'll see you there. Take care, everyone. Bye. Thanks, Alyssa.